Going back to colonial India in 1875, an era when Muslims in the country were seen as lagging in modern education. Sir Syed Ahmad Khan, a visionary reformer and educator, believed that education was the key to progress for the Muslim community. With this mission in mind, he established the Mohammedan Anglo-Oriental College in Aligarh to provide Muslims with access to Western sciences and humanities, helping them adapt to a rapidly changing world. This institution later grew into what we call today as Aligarh Muslim University or AMU. Fast forward to 1920, when AMU officially became a university through an act passed by the Indian Legislative Council. But then, in 1967, a legal twist changed its path. The Supreme Court ruled in S. Aziz Basha versus Union of India that AMU did not qualify as a minority institution under Article 30 of the Constitution. The court's reasoning? AMU was technically set up by the Parliament, not by the Muslim community alone. So it did not meet the criteria of being established and administered by a minority group. This did not sit well with AMU supporters and the debate only intensified. In 1981, the government tried to settle things by amending the AMU Act to affirm that AMU was indeed founded by Muslims for their educational advancement. But when AMU introduced a 50% reservation for Muslim students in 2005, the Allahabad High Court struck it down, saying that the 1967 ruling still applied. The High Court held that because AMU wasn't established solely by Muslims, it could not claim minority status. In 2016, the government further complicated matters by withdrawing its support for AMU's minority status, arguing that AMU had lost its religious character when it was designated a central university in 1920. These back and forth rulings over the years led to the matter being handed to a 7-judge bench of the Supreme Court in 2019 to clear up the issue once and for all. The Supreme Court's 7-judge bench heard arguments in the AMU minority status case over 8 days in January 2024. Reserving its judgment on February 1, 2024. The ruling came later on November 8, when the court, in a 4:3 majority decision, overturned its 1967 ruling in S. Aziz Basha versus Union of India, allowing Aligarh Muslim University to potentially regain its minority status under Article 30 of the Constitution. The Supreme Court majority, led by Chief Justice D.Y. Chandrachud, now says that an institution does not lose its minority character just because it was established by a legislative act. The Chief Justice highlighted if an institution was predominantly intended to serve a minority community's needs, that's enough to qualify it for minority status. According to this view, AMU's original purpose and the efforts by Muslims to create it could indeed establish its minority character. This decision means that AMU, if officially recognized as a minority institution, could gain more control over its admissions and day-to-day operations, including the ability to reserve seats for Muslim students and the freedom to operate with more autonomy. But AMU's case isn't just about one university. At the heart of this case is Article 30 of the Indian Constitution. Article 31 grants religious and linguistic minorities the fundamental right to establish and administer educational institutions of their choice, helping them preserve their culture and identity. As this case unfolds, we need to think about the bigger picture. It's not just about AMU, it's about how we protect the rights of minority communities in education without giving more power to the already privileged. If institutions like AMU are forced to open up reservations to all categories like scheduled tribes, scheduled castes, OBCs and EWS, while removing religion-based quotas, it could change how we approach education for minority groups in India.